This is the second of the key lessons on negligence, and we particularly focus on what we might have to think about in deciding or communicating to a client, if we're a solicitor, what are the important elements of negligence. Before going on that, I just want to go over the homework, because this is an important concept. And the homework was to refresh your memory on what the term precedent means. In a legal situation, a precedent is a ruling from a case with similar facts. And in fact, that ruling is binding on a court if it's been made by a court at a higher level or a similar level. For example, if a matter is being heard in the district court and a case with similar facts has been heard in the Supreme Court, that becomes a precedent. It influences the judge's decision because of the similar facts. Remember, when we're talking about civil cases, and a tort is a civil case, we're talking about common law, case law, the law that's built up by the ruling from cases, as being very, very important. As you're going to write your assignment, we're going to use the ILAC format. And that means we're going to look at 4 different things. First of all, the information, pulling out what the relevant facts are. The second is, what are the key legal issues that we've got to address around that? Thirdly, we're going to look at the arguments you're going to use, including the precedent cases, to argue your position. And thirdly is the conclusion, the details of the damages that you intend to claim and why you feel your client has a good case. Now we're back at the issue of negligence, and we're thinking about what the remedies are. The primary purpose of bringing an action is, in this case, in the case of negligence, almost always going to be financial compensation. And we break this down into 2 different areas. The first area is that around the damages around injury and loss. There are 3 areas of that. They include pain and suffering, emotional damage, and loss of enjoyment of life. You're right. The second lot of damages are those special damages that can be precisely measured, and they include things like replacement of property, a loss of earnings, a loss of profits from running a business. And keeping in mind that precedent cases, we've just talked about this, they're particularly important in determining the appropriate sum for damages. Now we come to a little bit of legislation that will be important for you guys to use in your answer. The Civil Liability Act of 2003 provides some limits on the damages. They limit the amount of general damages to $250,000, the pain and suffering, the loss of enjoyment. Now, that $250,000 is for a very serious injury, such as a brain injury, the loss of movement. This is significantly less than has been able to be claimed in the past. The same Act, the Civil Liability Act 2003, also limits the amount of damages related to loss of earnings. So that if you, for example, can't earn an income for a period of a year, you can't claim to have lost earnings that are greater than 3 times the national average income. At the moment, that's around about $75,000 a year, and that's measured by the Australian Bureau of Statistics. It increases over time. We now come to this issue of vicarious liability. That means liability for the negligence of another. And this comes down to the idea that if a person acts properly under the instruction of someone else, for example, that person might be an employer, that person might be a contractor, then the person injured sues the person giving the instruction, unless the employer or contractor acted outside the scope of the employment or contracting duties, or the act was an intentional wrongdoing. So unless those 2 things are in place, then the negligence sits with the person who was giving the instructions. There are 3 defences to negligence, and we're going to focus on this first one, contributory negligence. It's a partial legal offence that sees the damages reduced because the plaintiff is considered, in some situations, partly responsible for the damages. I've got an example here of a person who might be drunk while out shopping. They slip and fall on a wet floor that's not been properly cleaned. It's considered that their action of being drunk sees that they have to take some responsibility. They are contributing to the situation. They have some level of contributory negligence.
Attention. Zach Costello,
However,
please go to after
they might
school
still
care.
assess
Zach
that the store is
Costello,
negligent.
thank you.
In this case, let's say the damages are assessed as $100,000, $20,000 for pain and suffering, $80,000 for loss of income. But the fact is assessed the store is only 30% responsible. The person, because they're drunk, is considered to have had 70% of the contributory negligence. In this case, the store will only have to pay $30,000. It is the Law Reform Act 1995 that ensures the defence of contributory negligence applies in negligence cases in Queensland. Other defences include the voluntary assumption of risk. For example, if you're out water skiing, you're assuming some risk because it's a dangerous activity, or the illegality of an activity. That is, if someone is behaving in an illegal way, there's not a duty of care that needs to be extended to them. These are less important defences. The Personal Injuries and Proceedings Act 2002 also makes it clear that if a person has been taking recreational drugs, including alcohol, it doesn't lead to a third party having to extend to them an increased duty of care. This then leads us to the task for the day. And that is this. You have to come up with a conclusion around this situation. A council builds a set of swings, the contractor is swings and stuff, they follow specifications for the building outlined by the council, and a council inspector signs off on the finished swings. Someone is playing with their son on the swing, Dan. He runs up to the swings and jumps on it from about 1.5 meters away. The swing breaks and Dan hurts his back. On investigations found the council regulations have only allowed for material that the swing seat supports someone 75 kilograms in weight. Dan can't work for a year and loses the ability to be a bagpiper in a band. The task that goes with this, you are a lawyer who is advising Dan. It's your job to decide whether Dan has a case of negligence or not, and you are to use this format that we talked about to discuss it, the ILAC formula. Start with the information, pull the relevant facts out. What are the legal issues and law relate to the case? What are the arguments that you're going to use? Are there precedent cases that are worthwhile? And what conclusion do you come to around the issue of compensation and why you think your client has a case or should follow this course of action?